Good evening, everybody, and welcome. Thank you for attending this important and timeous discussion around the state of the dispute resolution marketplace. Of course, people who've been talking about mediation and arbitration as alternative dispute resolution mechanisms have been talking around this for years. If you've been a lawyer for long enough, you would know that there have been ongoing discussions around how we can better serve our clients and achieve resolution of their matters without having to go through the lengthy court processes that litigation has inevitably become. But I should start by saying thank you to the Chartered Institute for Arbitrators for agreeing to host this event with us. Thank you. We really welcome the opportunity to host our colleagues and some of our clients in talking about the issues. And then, of course, I'd be remiss in not welcoming the DJP, Deputy Judge President Roland Sutherland. Thank you very much for coming along to help us talk through some of the issues that we're dealing with tonight. I'm not going to be introducing Judge Sutherland. His CV is considerably longer than I can talk about. But there's one thing that I need to say about someone who's been a lawyer and in the profession for 50 years. Firstly, just think about that. 50 years. He's a lawyer's lawyer and now a jurist, and a jurist for quite a considerable period of time, who has profoundly influenced the ways in which jurists approach the law and has continued to play a role in teaching and training legal professionals. He is an absolute exemplar of what lawyers should wish to be in terms of just helping lawyers behave professionally and ethically in advancing the cause of their clients and, of course, advancing the service of justice. So, Judge Sutherland, thank you once again for making yourself available. I would have thought that you're sitting with the third division role, or at least allocating the third division role, but here you are, talking to us, as you always do. So thank you for being here tonight. One could say that the Judge President sort of pulled a pin on a hand grenade when he issued his directive. I'm not going to talk about the fact that, as you all know, it's now been challenged, because I think that is a separate matter, although not an unimportant matter, but a separate matter from what we are here to talk about tonight. And what we want to talk about tonight are what are the ways in which we can advance mediation and arbitration, the legality of whether or not the Judge President was empowered to be able to issue the directive that he has is ultimately going to be decided by the courts. But that is, in fact, a side matter, and I hope that Judge Sutherland will think that as well. I'm quite sure that there are enough agent provocateurs in the 40 people that are here that are going to raise the point pertinently anyway. But that is not the purpose of today's conversation. Today's conversation is about how do we take the service of our clients forward. Lawyers are often accused of only being interested in processes that serve their own pockets. Some of it rightly so, but it is not universally true of lawyers, and certainly the commercial law firms have been advocating for arbitration for the longest time, to the extent that we've also included and have universally included arbitration clauses and mediation clauses in our agreements for the longest time, because we feel that getting to legal certainty, especially for our commercial clients, is very important for their businesses. So it makes complete practical sense. But of course, what the Judge President is obviously trying to do is to unburden what is currently an unmanageable and unserviceable client demand for litigants who have matters that need to be decided. And the question is, how can we achieve justice for clients and at the same time make sure that justice is in fact served for those clients? And this is not really about lawyers making money, although inevitably lawyers will always make money, whichever way you look at it, because in mediation and arbitration, we have to provide very similar levels of service, notwithstanding the fact that they don't have the formality of court processes. So how do we get this right? How do we get this done? How do we support the initiative launched by the judges, irrespective of the fact that it may be subject to challenge? My sense is that whatever the outcome of this is going to be our future, and it needs to be our future, because there is simply no way, unless someone has a very bright idea and knows things about our budget that I don't know, we are never going to have enough justices to service the amount of litigation that is in fact emerging from our courts. I suppose the last thing to say before I hand over to Henk is that, of course, this is a very interesting time in the world for us to be talking about dispute resolution, because it looks like the entire world has gone mad. You know, I think of Rudyard Kipling and his poem If under these circumstances, because it does look as though the world can do with a bit of arbitration and mediation, given the kinds of things that we're trying to deal with. So, in a sense, you know, maybe we can pat ourselves on the back. Once again, South Africans can take credit for leading the way in terms of finding ways to get things done. So thank you. I wish you a very, very good and interesting debate. And please, the agent provocateurs, just slow it down. This is not a conversation around legality and ultra vires. This is a discussion about the merits of mediation and arbitration and how we get this right. Thank you. And I hand over to Advocate Henk Louw. Thank you, Advocate.
Good afternoon. Brent and Jack, well, thank you very much for today. It's wonderful to be here with you and to make use of your facilities. On behalf of the Chartered Institute South Africa branch, hopefully soon the Southern Africa branch, we thank you for attending our in-person event, and for those that are attending by way of Teams, I understand there's a few in Europe and in the Cape. Thank you for that. By way of general introduction, in the litigation process, there are a few issues of concern: time, money, and sound outcomes. And in going forward and in deciding to do anything, I assume the sound outcomes with the money issue is top of mind. That then brings into question whether there are indeed cost benefits and time benefits of running the arbitral process. And hopefully tonight we will convince you that there are. Within our current arbitral environment, we do have limited resources, as Brent has referred to, and we in the alternative dispute resolution environment consider ourselves to be a good alternative, a good parallel process that can supplement and see in a complementary manner whether we can reach a beneficial outcome for our clients in resolving disputes. Now, what we currently do have is the Rule 41A mediation process that has kicked off and is hopefully going to run beneficially and alleviate or take away the problem that we have in terms of the court rolls being congested. As such, arbitration, the arbitrational environment is a process that can assist where parties do want to run their matters before a person, a judge, or an arbitrator, to have the dispute resolved by a third party. And in those circumstances, we, in our environment, are fairly lucky in that we have a few arbitral institutions that can deal with this. AFSA's the Association of Arbitrators are there, or is there, as well as the Chartered Institute. All of these bodies have effective roles, have competent people, and have procedures to run ad hoc arbitrations, and with AFSA, administered arbitrations, both domestic and international. Our institutions have rules that cater for everything, and of course the AFSA international rules is also something that's been adopted in the BRICS arbitration as their set of rules in 2023. We are indeed happy and honored to have that. In addition to the process of arbitration in terms of cost and time, there are other benefits that one should also consider. Often there's an emotional benefit of parties not being able to perform or not carrying on until such time as they've finalized their dispute, time being of the essence. In addition to that, I understand there's also some psychological impediments on parties in not having their disputes resolved over time. The speedy process that we also further provide also ensures that evidence, parties and witnesses are protected in taking it forward. Once Brett has spoken tonight, and after the DJP has presented his topic, I'm sure that you will be convinced with us, and you'll be able to convince your clients that we indeed have a process which is time beneficial, cost beneficial, provides an expedient resolution of issues by way of its flexible scheduling in circumstances where we can provide you with binding and proper acceptable outcomes to ensure that parties are happy with what has happened. Now, within this process, and having discussions with Brett in the last few days, we've looked at some numbers, and one number that astounded me is in the international arbitral environment, AFSA had dealt with the matter to the value of some 3 billion rand. That matter took some 18 months to resolve, and the arbitral costs of that was some 4 million. Now, if you take that type of cost and you take it over time, you take the inflationary value of money, and you take that which you've lost awaiting a hearing, that on its own is some benefit. Now, in putting together this evening's program, we approached Judge Sutherland, and thank you for agreeing to talk to us. And what we did is we said, would you talk to us and would you choose your topic? And the topic that we have tonight was put forward by him. Of course, we did try and tinker with the words and we were told not to. And the topic as it was chosen is here. The dispute resolution marketplace, the place of litigation, arbitration and mediation, policy options in meeting contemporary demands for effective process and sound outcomes. Now, with the effective process and the sound outcomes, we then thought it proper to test the market and see if there's indeed a value consideration in terms of rand and in terms of time. We then requested Greg Whittaker from Algorithm Consultants and Actuaries to deal with this issue. And we presented the following topic to him and also accepted by him. Is there an argument for arbitration instead of litigation from a cost-benefit perspective? And he did some modeling, and tonight he will present to us his preliminary findings. After we've dealt with those two topics, we will then have tonight a general discussion with the panel. Jack will moderate the panel, and we will deal with various issues, take questions, and enter into discussion. Our first topic then is the DJP and what I've put forward. Now, what I did then do is I asked Microsoft Copilot AI to provide a shortened curriculum vitae of Judge Sutherland. And it came out with the following. He's a South African judge who has held several prominent judicial appointments. He is currently the Deputy Judge President of the Gauteng Court, one of the busiest courts in South Africa. His legal career spans decades, beginning as a court clerk in 1968 before becoming a prosecutor, state advocate, and later an advocate at the Johannesburg Bar. He acted in various judicial roles: Judge of the Gauteng Division from 2012, Acting Judge of the Supreme Court of Appeal in 2020, Labour Court Judge, Appeal Court in 2014, and acted as the Deputy Judge President 2019-2020, whereafter he took permanent appointment. His legal expertise is specializing in labour law, human rights law, and arbitration, and he has written several groundbreaking judgments. On an educational level, he holds a BA in History and Law, LLB, High Diploma in Tax Law, and an MA in Applied Ethics, University of the Witwatersrand. Of course, what AI did not mention was the laudable approach to promoting alternative dispute resolution and pushing the 41A mediation process. And of course, we all know about the Big Bang Week in an attempt to reduce backlog times from 17 weeks to 12 weeks, and indeed, a unique and interesting process was created. And I hope that we're going to have that going forward in bringing our mediation to the parties and also ultimately arbitration as an accepted process going forward. With that, the DJP.
Right, is this gizmo working properly? I'll just elevate this slightly. Well, good evening, everyone, and thank you, Henk, thank you, Brent, and I'm delighted to share this platform with Greg Whitaker, who in the past has been kind enough to come and educate my fellow judges on aspects of road accident fund computation. And I'm delighted that there are so many people who are sufficiently enthusiastic to take this topic seriously. There are wonderful opportunities which present ourselves in the dispute resolution market at the moment. And if there are those who have the energy and the insight to see those opportunities, the marketplace as we understand it can be developed, expanded, improved in ways which I hope I'm going to give some pointers to. The critical question really is how are we as South Africans to get our disputes resolved effectively? And that's a wholly practical exercise. The prudent approach, I think, is to recognize that although it's fun to theorize, what we need to do is to draw on the concrete social conditions of the society which the system of dispute resolution is supposed to serve. We are a society of free people who freely engage in disputations, and we are a mainly urban and mainly industrialized society with huge class differences. So the demands on dispute resolution are varied and frankly colossal. What I think we often, as professionals in the legal profession and the ancillary professions, overlook is that the vast number of disputes between people get resolved amongst themselves. And we tend to overlook that people are quite capable, under certain conditions, of resolving their own disputes, however roughly or readily that may take place. It's really only when conflict between one or more people is not susceptible to a genuinely private resolution through negotiation and discussion that we need institutionalized systems of dispute resolution. And that's really where our interest is here, as professional dispute resolvers. And when we talk about institutionalized systems of dispute resolution, we're talking about the arena in which strangers come into the picture in order to drive a process of various kinds towards a resolution. Now, the state provides a system of courts which apply the law. This is our public system. We can regard it as the community's default dispute resolution system. But however we title that system, and however much we give it the trappings of dignity and glory and status and all the rest of it, in the context in which we're discussing dispute resolution tonight, this is just the state-sponsored dispute resolution system. In functional terms, that is what it is. And there is no need to, in the context we are discussing it, to give it iconic status. The value of every dispute resolution process lies in the value it adds. Now, in any society, the court system is dependent for its efficacy on a number of factors. The key factors, obviously, are the available resources that the state is in control of to provide both human resources and financial resources. And when we have a state that is organizationally or financially weak, the vulnerability is reflected in the degree of effectiveness of the court system. And alas, that is us. That is the South African condition. Now, if we are to be insightful citizens, we need to recognize that there are two interwoven approaches to this particular problem of the state court system being starved of resources. The first is that we obviously have to support the state system, and there's an obligation, a self-interested obligation on the part of the professions to support the state system. But secondly, we need to recognize that the burdens that lie on the state court system can be shared by the professions in other respects. Because what the litigating public really is entitled to from us as professionals is a comprehensive system of dispute resolution that interlocks these various mechanisms of institutionalized dispute resolution, whether they are public or private. And when we ask about value add, we need to look at the holistic picture. So this is the mindset that informs my approach to this subject. Now, obviously, I approach this matter chiefly as a judge, and I'm acutely aware of, and I seek remedies for what, frankly, is the chronic fatigue which besets the South African courts. The implicit promise from the state is to render an effective litigation service. But in circumstances where it cannot do so, then the state must morally, sensibly, and usefully acknowledge that alternatives must be sought, alternatives that draw on the resources of society at large, more especially the resources that are available from the professions. I offer as a concrete illustration what is happening now in my court. The heavy reliance on acting judges, pro bono and stipendiary, is the illustration which makes the case. There are 38 judicial posts in Johannesburg. Every week, 5 to 6 practitioners volunteer to come and do the work of a judge free. Just compute what that would have cost the state. Those additional 5 to 6 judges add 15% to the complement of judges who are appointed. We've realized that the absence of significant additional judgeships is a problem which needs to be addressed both in the short and in the long term. But the fact that we supplement our complement by 15% is not our only problem. The pro bono judges, which come and help us out, for the 1 or 2 weeks a term, 53 practitioners volunteered to sacrifice their income earning capacity in order to fill those slots in the course of a term. But because Johannesburg is a nursery for the higher courts, we export our people to the SCA, to the Constitutional Court, to the Labour Appeal Court, to the Land Court, to the Competition Appeal Court. There's hardly a term that goes by when half my bench is not here. And we have to supplement those vacancies who are away deployed on those tasks, or vacancies which simply are not filled and we wait for the next round of appointments. This term, 16 posts are vacant for that reason. 33 practitioners have been marshaled to act for either the whole of a term or for part of a term. So in one single term, 10 weeks, 53 people were working for nothing, and 33 practitioners were hauled out of their practice to come and prop up the state-sponsored dispute resolution system. It's an unhappy picture. Now, in the long term, being a chronic iconoclast and reformer, I'm happy to tear up everything we've got and start from scratch. There's no doubt that total revision of our civil procedure system is long overdue. What we have understood in Johannesburg is that within the system we've got, which has a lot of dysfunctionalities and wastages, we've had to leverage what we've got as best we can in order to squeeze out the most. And we really do need a complete revisit for our civil procedure system. One of the ideas that has been floating around for quite some time, in order to focus on the end result and to get there more quickly, is to question whether it's appropriate to start actions by way of a summons. Why don't we, say some, start everything on affidavit? And there's a lot to be said for that. But these are long-term ideas about reforming the system. Our problems are more immediate, and much of what I have to say tonight is focusing on the immediate and medium term and what is feasible to engage in by way of policy reform. So these are the propositions that I'm going to advance tonight. There are three. First, I want to argue for a restructuring of the staffing of the High Court by the incorporation of permanent High Court judges on a part-time basis. And I'll elaborate on that in due course. Secondly, I argue for a filter for cases en route to court through the processes of mediation, the Gauteng model, which I shall address shortly. And thirdly, I argue for a diversion of trial work away from the High Court to arbitration, and to amplify and expand the arbitration market by offering people, through an amendment to the Arbitration Act, the option of opting into an appeal to a full court rather than a review. Not to supplement, not to substitute the current arbitration market, which in the corporate field is strong, but to expand the market. So these are the three propositions I want to address. But let me deal briefly, first of all, with what we might call a sociology of litigation. The litigation market, and I use that in the broadest sense, is a highly segmented market. We need to recognize that what goes on in family matters or personal injuries matters or corporate disputes or claims against the Minister of Police, as the case may be, all have very different dynamics and call for different skill sets in order to deal with them. We've recognized that in Johannesburg by introducing the family court, which on all accounts is working marvelously, and more recently the introduction of the insolvency court, which will sit for the first time next week. We recognize that the court system is an integral part of our economy. And if we are going to have a credible economy in which not only we who are here want to invest, but those who are abroad want to invest, the legal system has to be appealing to people who need the economy to function properly. It is not an underestimation of the significance of an effective litigation system that it is a key economic indicator for investors. And so we must contextualize our dispute resolution processes in broader social dynamics of the economy and of society at large. So let me now deal first with what I've described as the chronic fatigue affecting the state system of courts. Why are we in the position we are? It's quite simple. There are two explanations. The one is the state has no money. Those of us who have watched the budget debate somewhat cringingly will now be left in no doubt that there is no money in the kitty. We are in an awful position financially as a state. And the expectation that solutions that require money to be thrown at them will not be forthcoming. The second problem we have with the state is that those who hold power, the Minister of Justice, the Minister of Finance, are not interested in our problems. Or can I be kind to them? If they are interested, they have deftly concealed their interest. And a Minister of Justice without imagination and without commitment and without engaging those who are in the trenches is unlikely to be able to influence public policy in terms of spending or other adjustments. So let's recognize the state has no resources. The state has not done nothing. The former Minister of Justice appointed what is called the Moseneke Committee to produce a report on the expansion of court services throughout the country and on the capacitation of the courts. It is a piece of work which I shall decline to describe in public. Safe to say that it is deeply disappointing and despairing. The only useful thing to come out of that report for our purposes discussing this topic is that the committee has recommended a blanket 20% increase in judicial posts across the country. Now, were that to be implemented, it would mean that Gauteng would get 16 more judges, and let's assume there's 8 in each seat. That more or less covers the 5 to 6 practitioners who are working for free at the moment. But what would that produce if we simply abandon the pro bono scheme, which is totally reliant on volunteers and, of course, is not in the long term sustainable? What would that achieve? I have in the past published a bulletin of our lead times. And as we know, the major portion of the proposition for mediation as a filter is because we're offering people trial dates in 2032. That's with an additional 5 to 6 people working every week. We would overcome the embarrassment of the state accepting professionals working for free by having stipendiary appointments, but our capacity is already exhausted and we're underperforming even with an additional complement to that effect. The result would be that although an additional 8 judges would be welcome, if we were to address the lead time problem, not only in civil trials but in other matters as well, we would still be going to the profession and saying, will you come and help us for nothing? Something I'm acutely aware of has been the most astonishing act of generosity by the profession, and for which I can offer only my thanks. Not one single word of appreciation has come from the ministry. I saw a minute of a meeting with the heads of court and the Treasury, where somebody in the ministry head office had the audacity to say that some divisions overuse acting judges. That's the attitude from there. So the innovation of such an additional capacity would still not meet the requirements for us to be able to claim we were offering an effective litigation service. But let us suppose that tomorrow the Minister of Justice said, there's your 8 judges. Who do you want? You cannot manufacture 8 judges overnight. As it is, there are 13 vacancies in Gauteng right now. We advertise once a year. 8 posts are going to be advertised in October. You cannot recruit 13 judges at once. Even recruiting 8 judges at once is a tall order. Judges are grown. We would probably take 5 years incrementally to be able to bring up to strength permanent appointments for an expanded bench in any event. So how does this ultimately affect court efficacy? It would be helpful, but frankly, we're virtually standing still. We need to go further. And outside of the capacity of the state to fund and organize and provide, we are therefore obliged to take a more holistic view of the dispute resolution market and look at how we're going to share that burden with the resources society has. And that brings me to my first proposition: to staff the bench with part-time permanent judges. This is not a novel idea I put forward. This happens in England, in Ireland, in Canada, and New Zealand. In most of those jurisdictions, it's at lower levels that part-time judges are appointed, but in England, it's applicable to the High Court as well. And what, by way of a concrete proposal, I would have is that one would go before the JSC, which would resolve a number of debates about both the quality of people who have acting appointments and who should make the decisions. And one would get a 10-year appointment, and what one would do is serve for 1 term a year. This has, first of all, the advantage of being extremely cheap, because you don't have to provide the judge with the status symbol of a R1 million motor car. You do have to provide him with an office and a secretary, but you don't have to provide for his pension either. So the cost to company, so to speak, is considerably less, and it would be a bonanza for a financially strapped state to fund those kind of appointments. There's also another huge advantage, a functional one, is there are many senior practitioners who are specialists in their field who are reluctant to accept an appointment as a generalist, but would be perfectly happy to serve as a judge in their specialist field. And we could attract part-time permanent judges to come and serve in their specialist fields, whether that's insolvency or any other particular specialism. And the pilot project for that, in fact, has been the family court, wherein every week I have a practitioner who's a specialist family law practitioner sitting with a permanent judge dealing with family law matters. The same thing is going to happen with the insolvency court. We will have one specialist practitioner serving as an acting judge in that court, and already those posts for the rest of the year have been filled. The Judge President has directed that from the 3rd term, all insolvency matters will come to the insolvency court in Johannesburg, and the permanent judges will be drawn from both the Pretoria and the Johannesburg benches to do that work. It also has the flexibility, if you're a part-time permanent judge, to be deployed anywhere in the country. So flexible workflow requirements. If you had a specialist insolvency practitioner, and in Bloemfontein, the Free State Division had a substantial number of matters of that nature, one could deploy them there. One doesn't have to be selfish and keep them all in Gauteng. So that is the first policy option I think we seriously have to consider and punt. The second policy option, also as an adjunct to cure some of the problems of the court system, is mediation as a filter to regulate entitlement to court time. Now, mediation, generally speaking, in the South African experience, has been voluntary. And the fact that we in Gauteng have now made this protocol which requires as mandatory obligation mediation does not mean that voluntary mediation is not something that enjoys plausibility. I think there's a great deal of advantages to be drawn from voluntary mediation, the most self-evident being is that it's the first proof that two parties actually want an agreement. Mandatory mediation clearly has to have a slightly different dynamic where you may have to drag one party to a mandatory mediation. What justifies mandatory mediation? External forces, as is illustrated in what we've done here in Gauteng. It's a response to a need which otherwise cannot be addressed. And we need to recognize that the novelty of mandatory mediation is an exaggeration. The Law Reform Commission, who has put out a bill, has unequivocally shown where the policy directive of the state is going. It's true they have somewhat meanly a limited number of circumstances where mediation will be mandatory. All of them seem to imply the computation of damages in one form or another. But they have then reserved a questionable reservation, a power to the minister to add anything else. So whether that's simply a indication of a lack of consensus on the commission itself, or whether they simply didn't have the imagination to appreciate why mediation would not be available to everybody, remains to be seen. And I'll come back to the contingent status of that bill. The Land Court already has the power to mandate mediation, and although it has many warts, the Labour Relations Act has made mediation compulsory in labour relation dismissal disputes for 30 years. So the novelty of mediation is exaggerated. In England, many of you will know of the decision of Churchill versus the Merthyr Tydfil County Borough Council, the Weed case. Who would have thought that Weeds next door could have led to a High Court decision which has gone round the world, where the courts will now order people to mediation. In Australia, interestingly, they have a mantra there about mandatory mediation. They say, as long as the outcome is voluntary, it doesn't matter that there's a compulsion to mediate, which seems to me to be quite a folksy way of making an obvious point. There is, of course, risk of abuse. Those of us who are familiar with the CCMA know that there's a great deal of ritual compliance, and in our protocol we have taken steps to avoid that. There is the argument about extra costs, a wholly misrepresented proposition in my view. If you want to tell me that on the bill of costs at the end of the matter there'll be another line item, I agree. But in the context of the overall costs of litigation, the blip that a mediator's fees would cost is hardly noticeable. Now, in the Gauteng model, the directive is unequivocally a filter to deal with our concrete problem. What needs to be appreciated is that implicitly the protocol incorporates Rule 37A. Intrinsically, if you're going to mediate a dispute, the functional distinction between that and case management is hard to find. You need to shape up what the real issues are. You need to see which ones can be swept away and resolved peaceably, and where the big hockplekker are. We've effectively outsourced case management. As many of you would be aware, there's a moratorium on case management in Johannesburg. And prior to that, our bulk case management system we had to abandon simply because the road accident fund just didn't turn up. And you do need two people to tango if you're going to have case management. But the mediator's role here, upon being seized of a case, is effectively to case manage it to where you identify the points of issue and then see whether you can resolve it. What you can't resolve is then listed, and then one approaches the court for a date. I'm not going to drill down into the technicalities of the protocol. The one criticism I have of our protocol is that it's far too long. I'm sure we could have said all of that in much, much less space. Maybe it was just to print it in small font and stick it somewhere like that. But I'm talking about the model. And what is the model that we've put on the table? When we first engaged with the mediation organizations, of which there are many in Gauteng, and I may say incidentally, in Gauteng, if not elsewhere, we are spoilt for choice because there is really a deep pool of mediators and organizations which have decades of experience. There's four things to make the protocol work and for the mediation market to function appropriately. We need a pool of mediators who are accessible to the litigating public and who are credible because they've been credentialized by credible accreditation societies, and they've got to be affordable in relation to the segment of the market that they address. Now, in two respects, mediation in this sense is well established. In family law, for example, mediation has been around for as long as I've been in practice. And there are many members of the legal profession which have become full-time mediators in that field. There are several ex-judges who have a particular interest in family law who mediate frequently in that field. Charging fees appropriate to those circumstances. If you're going to mediate a dispute between Anglo-American and LTA, that's a quite different market. And so what we will see evolve is a segmented market addressed by mediators who are addressing the particular skill set that they can offer. I saw earlier today a flyer from Conflict Dynamics in which they are offering training in exactly the way I'm describing it, giving people substantive insight into the various segmented markets for where mediation can play a role. And of course, what in the Gauteng model you've got is the judicial oversight. And the idea is that the judge president or one or more of his deputies will be monitoring the process, both organizationally and in terms of the quality of outcomes. I don't deny that there's a risk of abuse and of a slippage into ritual. I don't believe that it's safe to bet on there not being at least one person who will sell a mediator's report for 1,000 rand. But we will have to ferret those things out. And by and large, those are peripheral problems. But to sum up on this point, the second proposition I'm arguing for, if we are going to both support the state court system in its distress, if we are going to share the burden of the state court system by drawing on the resources of the professions in its broadest sense, then mediation in this sense, in terms of the Gauteng protocol, is an ideal means to achieve that. But let me move to the third proposition I argue for, and that is an expansion of the arbitration market. At the present moment, the arbitration market in Gauteng, if not the country, is largely dominated by the corporate market, and rightly so. That market need not be disturbed, but there is room to expand. There are a lot of litigants, not the habitual litigants, who are nervous about arbitration because it's a one-off opportunity unless you can find a review ground. Many of those litigants may find comfort in having the backstop of a full court appeal if they are able to articulate proper grounds for being dissatisfied. Now, functionally, how does that help? It's obvious from what we've done and why we have the mediation protocol is that we just don't have the capacity to hear all the trials. One knows about the trials that have been set down till 2032. What about the invisible queue that have yet to reach the registrar's office? Now, we might not be able to hear 100 trials, but if 10 of those trials go to arbitration, if 100 of those trials go to arbitration and 10 of them end up having an appeal, we can find the capacity to hear 10 appeals, but we can't hear 100 trials. And it seems to me to be a matter of common sense that this is a policy option which needs to be pursued. The capacity to meet the demand for that exists, and it has all the usual advantages of arbitration. What it also can do, and certainly the court system cannot do at high court level, is deal with a dispute between people who are living in Messina and in Newcastle, whereas an arbitrator in Johannesburg could hear their case on a video link at much reduced cost and satisfy everybody, because there will be that pragmatic option to do that. In addition to that, of course, there is the need to speed up enforcement of arbitration awards, which is something that has been spoken about on a number of occasions. Judge Borachowitz, who's here with us tonight, and I have addressed how that might be done on a number of occasions. And that is another aspect which comes into play in making arbitration in a broader market a useful part of the comprehensive dispute resolution market I'm talking about. So those are the three propositions. Expand the capacity of the High Court bench, not only by adding more permanent judges, but by extending that by recruiting specialists for part-time appointments on a permanent basis. Embrace mediation as a filter and service the mediation requirements through the pool of mediators which are available. And thirdly, divert work which clearly the state system cannot cope with into arbitration where there's the possibility of buying into an appeal if you so choose. So the question must then be asked is, so what are you going to do about it? And that's really my punchline this evening, is what's the role of the profession in advancing these policy options? There's no competition between the three options. They are interlocking. We're broadening a market, and what we need, of course, is political pressure on those who can make these things happen, where the law needs to be changed, and we need energy on the part of the professions to generate the capacity to service the dispute resolution market in this way. A lot of the arguments I've advanced, which articulate despair about the position in which the judiciary finds itself, are arguments in favor of judicial autonomy, something to which the government paid lip service, but has not been willing to move beyond the quite frankly dysfunctional office of the Chief Justice. The profession need to make a noise about that. The problem of dispersed responsibility is the ideal opportunity for no one to take responsibility for anything. I'm going to tell you a real story which counts as my one joke. Every term we have a meeting in the division called the efficiency meeting, where everybody who's interested in the court can come along and whinge to me about why we're not doing what they want. So we've got everybody there, the bar, the attorneys, the sheriff, the prisons, the prosecutors, the police and everything else. We also have the Legal Practice Council. And at the meeting we had in the middle of March, the representative of the Legal Practice Council thanked the court manager in Johannesburg for providing a branch office in our building. And having thanked her, he then added the caveat. He said, however, I'm sorry to have to tell you, but you have a rodent problem. So I held my tongue. I didn't ask whether they'd been properly admitted to practice or not. And the court manager then responded to say, yes, I know about the rats. I have reported that to the Department of Public Works because they are responsible for getting rid of the rats. But when I spoke to them, they said, I'm awfully sorry, court manager, there's nothing we can do at the moment. We have no money. Please request again after the beginning of the new financial year on the 1st of April, and then we will process your requisition to get rid of your rats. So that was good enough. But then, this is the piece de résistance. She says, unfortunately, seriously, she said, unfortunately, your problem is not cockroaches. If your problem was cockroaches, then the Office of the Chief Justice could have done something about it, because we are responsible for getting rid of the cockroaches. But the Department of Public Works must deal with the rats. Now, I tell that story against nobody except the mindless, bureaucratic, I don't know if there's a proper verb or noun for that. How can you run anything when you've got that level of obtuseness? And that's the root of many of these problems, and it won't be resolved until the judiciary's got proper autonomy. So where do you start? Not only with yourselves and with your clients, but if you're going to breed a mindset that endorses what I've been talking about here tonight, that sees dispute resolution in a comprehensive sense, where various sources must be drawn on, various mechanisms can be integrated and synthesized, you need to start with conscientizing the law students. Over the next 20 years, what we want to see is a critical mass of young lawyers who are not afraid or contemptuous of thinking laterally about dispute resolution. There may well be dinosaurs amongst us who for 40 years have worked in a particular way and are not brave enough to compromise on what has worked. But the upcoming generation and yourselves need to assiduously work at creating a professional mindset where you embrace these things pragmatically and bear in mind that the Holy Grail is an effective dispute resolution system drawing on all the resources of our society and not finding yourself in a situation of impotence where you say, that's what's available and it's not working. So I encourage you to embrace that as your mission. Thank you.
DJP, your third option excites us, and we will be knocking on your door in the next couple of days to present one or two things to you. On our second topic, effective outcomes and sound outcomes and the resolution of disputes, we thought it apt, as I said before, to address the issue of costs and to see if we can indeed present to the public at large something which is cost effective in this process. And we've requested Greg Whittaker to deal with the perceptions associated with arbitration costs on the question, is there an argument for arbitration instead of civil litigation from a cost-benefit perspective? And he will present some of his preliminary modelling results to us. Now, Greg is a fellow of the Actuarial Society of South Africa, a fellow of the Society of Actuaries United States, And within the Actuarial Society of South Africa, he is a member of the Research Committee and the Damages and Compensation Committee, and he serves as a trustee of the Actuarial Sciences Education Trust. He's further an ambassador for the Actuarial Society of South Africa, and he is a participant, and he joined the examining writing team for the fellowship examination in retirement benefits. He's published peer review reports, both here and overseas. He has extensive experience in various aspects of litigation work. In 2008, he won the Reinsurance Group of American prizes for best published papers in an academic journal. And in 2019, likewise, he received the Actuarial Society of South Africa's Presidential Award. Greg, over to you.
Okay, good evening, and thank you to Cliff Decker-Hofmeyer and the Chartered Institute for Arbitrators for the opportunity to present the results of some preliminary modelling, which explores whether arbitration may be preferable to civil litigation from a cost-benefit perspective. We'll walk through the methodology, some of the key assumptions, simulations, and then early findings along with some implications for dispute resolution strategies. Going to get the algebra out the way on the first slide, so hopefully this is not going to put too many people to sleep, but it's just essentially it's a fairly simplistic model. It's basically comparing the present value of a net settlement amount under both litigation and arbitration. So some of the key inputs into the model are the current undiscounted settlement value. So I'll talk to the distribution of settlement values a little bit later. And then some of the other key inputs are L is the years until litigation concludes, A is the years until arbitration concludes, and typically A is less than L, but the model does allow for A to be equal to L and for, in some instances, arbitration to be longer than litigation. So it's a completely sort of randomized model. And then we also look at claims inflation, because every year that a claim is delayed, the figure may or may not increase. And then there's also aspects of fees. So F sub L is the legal and related cost percentage under litigation. And then we also look at that under arbitration. And then we have to select a discount rate to express everything in current day values. Something that hasn't been addressed, because this modelling is more or less been done in a sort of a commercial environment. So we haven't really looked at the personal injury environment per se, but a consideration would obviously be the actual chances that a litigant survives to the trial date, because that can be fairly substantial when you're waiting till, as Judge Sutherland mentioned, 2032 for a trial date. So your survival factor could also play a role. So if we look at, firstly, the distribution of amounts in dispute. So obviously the amount in dispute should not be confused with the ultimate settlement amount, because obviously the arbitrator will decide on that. But just interestingly enough, I've just done a comparison with the London Court of International Arbitration and the Arbitration Foundation of South Africa. Thanks to Advocate Vasileva for giving me that data. So if you just look at these, just to give you an idea of where sort of amounts are litigated, you could see that the vast majority of cases involve amounts under $10 million. And there are a couple of high-value disputes above $100 million. This does have some implications for the proportionality of arbitration costs, which may be more manageable for mid-sized value claims. So this just gives you an idea of the distribution of amounts in dispute. And then what we're really interested in is what is the distribution of settlement values. So there's very scarce data on commercial dispute values, but what we can do is do some estimation or some modeling. So what often happens in a short-term insurance environment, if you're modeling claims as an actuary, you often fit various statistical distributions to claim distributions, to claim amounts. And often a lot of the time you'll see a log normal distribution, and what that means is it's normally got a long tail. So you'll find there are some very substantial claims that sit in the tail, but a lot of the claims are, in this particular example, are clustered sort of under the 20 million rand mark, between say 5 and 10 million rand. So this is just an example of a distribution of settlement values that one would encounter. So that's as far as I'm going to talk about the settlement values for now. We'll get back to them later. Then there's obviously also another distribution you need to worry about, is the time to settlement. So here I'm defining the time to settlement as the period between the occurrence date of a claim and the settlement date. And the settlement date is the date on which the final payment is made and the claim is fully resolved. So litigation and arbitration form part of that continuum, but obviously at some stage the claim starts and you strategize as to how you're going to take the matter forward, prepare, decide on litigation or arbitration. But we've given illustrative distributions. Now, what I can say about litigation is that we've looked at around about 1,000, but these are obviously personal injury matters, and the average time from the date of the accident until the date that the monies are paid is roughly 7 years, with a standard deviation of about 3 years. So the vast majority take between 4 and 10 years. So that's just insight into what it looks like in the personal injury environment. In the commercial environment, we assume slightly less than that, and I'll discuss what those assumptions are when we get to the modeling stage. So this is, again, the time to settlement in practice and in the real world. When you're working in a short-term insurance company, ordinarily you would use a long-tail distribution to model the time to settlement. So a renowned one is medical malpractice. That's probably got the longest tail out of any claims that you see. That sometimes goes to as many as between 20 and 25 years in the tail. So, but obviously in commercial matters, depending on the nature of the matter, your distribution times will differ. So one of the important factors in modeling is claims inflation. And when we talk about claims inflation from an actuarial point of view, we normally talk about two types of inflation. So the one is economic inflation. So that's just simply the sustained increase in the price level of goods and services. And typically one thinks of the consumer price index, which is just a typical basket of goods that's measured. But as you know, everybody experiences inflation in a different way. And likewise, every claim has a different rate of inflation that would actually apply. So there are various sub-indices of the consumer price index. For example, you have building costs for construction disputes, or wage inflation for economic claims. So what this model does do is it allows for different rates of inflation, completely randomized rates of inflation in terms of claims inflation for each claim that's modeled. We look at the other type of inflation that one encounters is often referred to as social inflation. And those are aspects over and above economic inflation that may drive claims. For example, litigation, funding industry, legal advertising. Interesting statistic in America, the number of television ads has doubled in about 9 years. In actual fact, they spend about $1.2 billion a year on advertising, legal advertising. There's also other drivers, societal sentiment, for example, corporations, the perception that corporations choose profit over public safety. So these sort of factors can drive claims inflation. And just when one is reserving from a, for example, an insurance company point of view in terms of claims and how are these claims going to increase over time, you obviously have to be cognizant of various risks that may occur. So I've just listed a few of the things that are sort of on the radar in recent research from this is research taken from Swiss Reinsurance, where they're looking at various technological, medical, and environmental factors that may drive claims inflation. So I've just not going to run through any of these in any detail, but it's just these are sort of the considerations that one would need to sort of think through when you're setting assumptions and taking a view as to how claims may inflate over time. So in terms of the modeling process, like I mentioned earlier, we allow for the current settlement value to increase by various rates of inflation over time. So these are just three examples of three trajectories of what it would look like. So for example, if you had a claim worth, let's say 1 at the moment, then in around about 9 years' time, that claim will, 8 or 9 years' time, that claim may have doubled. So if you're waiting for if you have to recalculate settlement, recalculate damages as you move through time, those values keep on increasing. One of the reasons that it increases is that you're discounting for a shorter period of time. So for example, if you've got, let's say, a present value of a rental contract for 20 years, and you'll have a present value of that amount right now. But if you move through time and you wait another 10 years, the present value is going to have increased because you're not discounting the losses for as long a period of time. So, and over and above that, there may be other things that have influenced the claim as well. So I've dealt with so far the settlement values, the time to settlement under litigation and arbitration, and claims inflation. These are just a few points that I gathered in discussions with Henk in putting this presentation together, just in terms of some of the just high-level comparisons between litigation and arbitration that may result in a difference between legal fees and arbitration fees. So legal complexity, so under litigation, normally that's high, governed by strict procedural rules and evidentiary rules. And under arbitration, that's more moderate. There's more flexible and streamlined procedures. Similarly, with discovery costs, as Henk explained to me, under arbitration, disclosure obligations are often narrow and more focused, and arbitration tends to limit disclosure to essential documents. So, and similarly with the duration, we've heard of the delays in terms of court backlogs. I don't think there can be too much argument in terms of the when you're looking at the time to settlement, the part of that time to settlement that involves litigation or arbitration would be shorter under arbitration. And then obviously also third-party costs, the litigation as cumulative procedural costs. I don't have a huge amount of insight into legal costs because we generally, when we're involved just calculating damages, you don't really see what the final bill of costs looks like or things like that. But for the purposes of just doing some preliminary modeling, I've actually assumed that the legal fees would be about 30% of the inflated settlement value at the time that it's settled under litigation. So, for example, if you, in 10 years' time, if your settlement value is projected to be R1 million, the plaintiff would get out about 700,000. So those figures can be adjusted, but this is just for the purposes of some preliminary results. You can obviously, wanted to be more scientific, you could link fees to the duration of the matter, but I've just opted for a flat percentage for simplicity. And yeah, look, I mean, if the data were available, you could further research could perhaps, you could calibrate the model a little bit more to actual cases, but we would obviously need a lot more data for that sort of exercise. So the last ingredient in terms of the calculation is the discount rate. So what we find at the moment is we're in a high discount. We're in an environment of high real rates of interest. So in other words, these are taken from this is real data. This is a zero coupon nominal and real bond curve. So basically, what this means is that if you invested in the bond market, you could beat the rate of consumer price inflation by around about 4% in the short term, and that increases up to around about 4.5% in the long term. So, so in other words, you can most certainly beat the rate of consumer price inflation. Our nominal rates of inflation are projected to go out quite high over the long term. This is projected to be 12%. Well, you can lock into a rate of 12% now for 20 years in the bond markets. So while we're in this sort of situation, this basically increases the penalties for delayed settlements. Arbitration is being quicker would be more attractive in these sort of conditions, as it would suffer less from what we refer to as discount erosion. So the calculations that I've made, we've simulated 10,000 claims. So we've just they've all drawn from a distribution of claims. And then we've also, so that's a completely randomized calculation. You just use a random number generator, you seed the distribution, and then you'll get a settlement value, which looks pretty reasonable. I'll show you that just now. And then for each claim, similarly, you calculate a randomized time to settlement under litigation. So there I've assumed for commercial litigation purposes a mean of 5 years and a standard deviation of 3 years. And then under arbitration, I've assumed a mean of 3 years and a standard deviation of 1.8. So the model basically allows for things like arbitration to be less than the litigation time. They could be equal, depending on what the randomized generator does, or arbitration could be more lengthy. So it's a completely randomized process without any bias. For generating the randomized settlement values, what I did is I just assumed an average settlement value of about 8 million. That might be a little bit high in a commercial setting. And generally with commercial lines data, what you ordinarily find is that it's quite widely dispersed. So you turning back to that original amounts in dispute slide, you could see there's some matters that are sitting in the $100 million category. The model does allow for those sort of values to be generated. So in the first iteration of the calculations, the largest randomized claim out of the 10,000 claims was a claim for 291 million, for example. So the model looks at all these different values that get generated. Then in terms of the claim, once we've generated a settlement value, we allow for that value to increase over time with claims inflation. And for each and every single one of those 10,000 claims, we've allowed for a different inflationary trajectory. So again, those are also randomized. And then what we do is, using that discount curve, we calculate the present value of the values under arbitration and the present values of the amounts under litigation. And then we compare those two. If the present value of arbitration is greater than litigation, then there's a benefit to the plaintiff. And then we say, well, how much arbitration could that buy? So these are some of the results. So This graph on the left looks like pretty much a paint splash, but that's it just shows a distribution of claim settlements. So the outer ring are matters that were generated by the modelling process that are settled for 300 million rand. You can see the longest blue line there. That's the 291 million rand settlement value. You can see using the mean value of about 8 million, most of your claims are clustered below the 50 million. They're all within that first circle of 50 million. And then you've obviously got some of your outliers. So those outliers are all modelled. So what we do now is we say, well, what is the economic inflation rate? And one can, if we just go back 2 slides, you can actually derive that from the discount rate curve. So you can actually derive what the market expects inflation to be. And what it expects it to be at the moment is the gap between that red line and the yellow line, which is around about, in 2025, it's around about 3% or so. But you can see that gap gets larger as we go through time. So the market at the moment is expecting inflation in 20 years' time to be about 7% per annum. So and this is based on what the bond market is telling us. So we can see inflation is probably going to increase over time from the bond market, and expected inflation, should I say. And what we do then is also we also allow for excess inflation over and above economic inflation. And this is quite a crucial assumption, because if you're hypothetically in an environment where your claims inflation is exceeding the rate at which you can invest, then it actually pays for you to just hold on as long as you can, because you're going to just increase your settlement value in real terms. But when you're in a situation where your discount rates exceed your rate of inflation, it pays you to get the matter settled as soon as possible, because in current value terms, it's worth more to you. So we've just looked at a whole range of randomized excess inflation figures. So, for example, in the first year, you might have inflation of 3% plus another 4%, so your claim might have increased by 7%. Alternatively, your claim might have increased by 13%. So in the situation where your claim increases by 13%, it would be less beneficial to settle the matter early, because your claim is increasing in real terms. So the model caters for all of these different randomized processes. There's a lot of moving parts going on, but they're all random. So, and the reason we do that is to get some or other idea of what does the distribution actually look like over time. So what we found then is, in a environment where your excess inflation in claims is fairly stable, so the 0 to 4% range, almost sort of 50% of matters result in a higher present value, which would justify at least 2 days of arbitration costs. And then as the claims inflation environment becomes a lot more unstable, that figure reduces. But generally, depending on who the litigants are, I mean, if you up against an insurance company, for example, obviously for an insurance company, it's in their interest to try and keep claims inflation as low as possible. So, you know, you're unlikely to get to the sort of range where you're sitting at like consistently double-figure claims inflation over a long period of time. So these are just some of the results in terms of completely randomized claims distributions, times to settlements, inflation, and looking at the actual discount curve as it stands at the moment, where we have high real rates of interest. We find it's beneficial in a significant percentage of cases. So some of the next steps, I mean, this is obviously just preliminary modeling and just getting the ideas out there in terms of the cost benefit. But obviously one would have to do some sensitivity testing around parameters such as inflation and interest, further calibration to real world case data would be needed. But it's very hard to get values on settlement values on commercial matters unless you the pricing actuary for an insurance company, and and then just sort of engagement with legal practitioners to validate some of the assumptions, especially things around the cost assumptions. And then just some discussion questions. Don't have to discuss them now. Just maybe some takeaways in terms of what type of claims may arbitration yield the greatest financial advantage. And then something that Henk alluded to earlier is does the exclusion of qualitative factors such as enforceability, psychological impacts of lengthy litigation and precedent impact the decision-making framework. Obviously, this model is a purely economic model. I haven't looked into factors that would ordinarily enter into the decision-making process and which route to adopt. Obviously, personally, I wouldn't want to sit through a 10-year trial, but it's everyone has to make that decision. Also, one would have to look at how would the results differ if legal fees were modelled as a increasing function of time. You don't have much data or insight into that, and I just thought, for the purposes of this illustration, 30% was a reasonable sort of percentage. It might differ with me on that. And then just the data improvements, what data improvements are required in order to refine the assumptions further. And I think that's the end of that of this section. Just to summarize, really, it's just a cost-benefit analysis. So when you're doing a cost-benefit analysis, you should always look at things in present-day values. What's the present-day value of an arbitration settlement versus the present-day value of a litigation settlement? After all costs, I'll take it into account. And then if the present value of the arbitration settlement exceeds that of the litigation settlement, then it's a strong case for arbitration. And the model, the inner workings, there's a little bit more in terms of, I haven't given you all of the results. It's quite a lengthy sort of model, but you can sort of work out by sort of amount and how many days you can do certain amounts for and so on. So, but the key thing is really just when you're in a situation of a high interest rate environment like we are, then the benefits to the plaintiff of a higher settlement are much greater. Thank you.
Thank you, Craig, for that. I must maybe first introduce myself. Is the mic on? I'm Jack Will Ferris. I'm also a director at CDH. And I just want to again say thank you for everyone who found interest in coming to this event by Ciarb and CDH. We truly value it. And I will be facilitating a session now between the Deputy Judge President of the Gauteng High Court, Henk as the Chair of Ciarb, and also Gregory, who just gave us a very informed discussion about the cost benefit of having arbitrations as opposed to litigating, like looking at the long lead time of the trial for civil action. So I want to welcome all the panelists to the floor or back to the floor to have a facilitated discussion. And I think what we'll also allow for is if there's any questions from the audience, that burning questions, thought-provoking questions that you have that you want to ask, please feel free to do that. So I think I'm going to stand. Henk, do you want me to stand or sit? Whichever way. Let me sit with you. So just again, looking at the topic and discussion and what Justice Sutherland has unpacked for us in terms of the dispute settlement marketplace and where we're going or should be going in terms of the resolution of disputes in South Africa more broadly, but also what's happening in Gauteng. I think the first question is maybe to Henk with reference to the role of the private sector in particular, like Ciarb and other institutions in South Africa, including law firms. So how do we assist the judiciary looking at the constraints that Justice Sutherland has pointed out in ensuring that we ultimately achieve the objective or the policy options that the judges indicated?
Thank you, Jacob. So the thinking is to create a parallel process next to litigation. And in that process, the idea is to extract trial matters and possibly always also post-motion matters from the system and draw it into arbitration process. In that environment, in the event that arbitration is indeed more viable, costly and speedy, the parties can then opt out at any stage. And the proposal that we'll be making to the DJP is that at some point in time when the parties commence the proceedings, there has to be a clear indication as to whether or not they would like to opt out and run it by way of arbitration. And at any point in time, our proposal further is that parties may opt out of litigation up until the point where the matter is allocated or be heard by way of trial. And once that has occurred, and the pleadings have been settled and finalized, of course, all you have is a simplified cost of just paying for the arbitrator for the 2 or 3 or 4 days to hear the matter. We'll also be making a proposal to say that in the event of arbitral matters being referred to the High Court by way of review or by way of enforcement or by way of contempt, in those circumstances, we'd propose that the commercial court be used, and the thinking is to create also a specialized court in terms of an arbitral court or arbitral division that could hear that on a speedy process with members of the bar then making themselves available on the pro bono basis to assist the facilitation of the process. Now, once we can run that holistic process, we can put arbitration forward and ensure that we have a parallel process for litigants on a speedy basis.
Thank you. Maybe just a follow-up question. In terms of the process, where is that in terms of the drafting of the proposed rules? And has that been submitted to the Justice, or the court at least?
Well, we have drawn it and drafted it. There are various sets of documents available. We've also had the benefit of Professor David Butler at the University of Stellenbosch to have settled the finalized documents, and those are to be presented to the DJP for discussion purposes and seeing if we can take it further. So
Yeah.
we are, hopefully in the next couple of weeks, in a process to talk to the DJP.
And Justice Sutherland, so just in touching on, so this is the third proposition that you had in terms of arbitration and making sure, again, part of streamlining the judicial system or access to justice is having a arbitration system that more people can access, not just corporates, because as you've also pointed out, a lot of corporate entities by default in contracts, they would have arbitration clauses. In terms of the proposition that Henk has now put forward, what is your engagement also from a court's side with the private sector to ensure that is then expedited, except for this first engagement?
Well, there's a couple of self-standing aspects there. The one is, of course, the model in the way it's being presented would not be within the scope of the judge president to put into operation. So it's typical of a proposal one would need to take to the minister, to the heads of court, in order for some kind of rule change or indeed legislative change. So that's the channel you would be looking at.
It fell off. So at the back.
There we are. Right. Well, I'm afraid I'm technocratically challenged here. So I'm sorry I don't have bigger ears. All right. Okay, that done the job. Splendid. Thank you. So the question is, one would drill down into that and see what is viable. Political sensitivity is obviously one of the things that need to be managed. So that's one aspect. In regard to another aspect that I'm especially alive to is I wouldn't support a model which is dependent upon pro bono staffing of the court. Because although that's a legitimate interim measure, I don't see the virtue of designing something that assumes donated professional time. That's not sustainable in the long term. So we're talking about something that can match the capacity to meet it. That's a matter of principle. In the various examples that one might draw from where I've been responsible with or without others in channeling specialist matters into what we've called courts, perhaps somewhat pretentiously, because really all we're doing is creating a special role, like the family court and the insolvency court. Those decisions to create a specialist channel are principally dictated by volume. If there were only one or two insolvency matters a week, there would be no point in having a specialist insolvency court. As it is, on the preliminary figures which I've seen, we're likely to have something between 5 and 10 opposed insolvency matters a week, and something running up to about 20 unopposed insolvency matters, which is pretty much what one would expect a judge to get through in the ordinary opposed motion role, of which the insolvency court is really a subset. So that justifies that. Similarly, in the family court, there's enough work to justify two judges. I rather doubt that there would be enough work to justify a court specifically devoted to dealing with arbitration issues in relation to enforcement. The question of what should the court be doing in order to facilitate speedy enforcement of awards is something that's been spoken about a lot, and I mentioned it earlier myself. At the present moment, the system is simply this. If you've got an award and you want it to be enforced, you write me a letter and I'll find space for it, so it doesn't have to get lost in the queue. That's been on the table since 2021. Why is that? Simply because it's a lack of volume. I can stick it in the commercial court, just gets lost in the wash. If I take the opposed motion court, where that kind of matter would necessarily go at the moment, as a result of some changes which I made a fortnight ago to arrest the galloping lead time for the opposed motion court. And I'm not going to go into the details of that for present purposes. As we sit here now in the first week of May, the next dates available in the opposed motion court are in January 2026. Clearly far too long. About 2 years ago, the lead time in the opposed motion court was 12 weeks. And that's what I want to get it down to. One might argue that that's too long. I mean, I belong to the generation where if you had an opposed motion, you got it in by noon on Thursday, and on Wednesday morning next week you were arguing it. But the wheels came off that simply because volume outstripped the capacity of the judges to do it. So living with the model we've got now, if we can get the opposed motion court down to 12 weeks, one of the options that would be available is no special favors. You take your arbitral award 12 weeks later into a debate from the time it's ripe to be heard. That probably means from the time that the losing party said, I won't comply, you can probably double the time. So we're now talking 6 months from default to a hearing. In some arbitrations, that kind of debtor's defense defeats the very objective of the strategic decision to go to arbitration in the first place. But the management of those logistics is entirely pragmatic.
Thank you, Justice. I think that's a key point because for South Africa to sell Johannesburg as a seat of arbitration, more particularly international arbitration, it's important that we have the full support of the judiciary. And we see this on a regular basis when we interface also with international clients where they say it takes too long for things to happen in South African courts. So, and examples is also when you deal with, and this is specifically with reference now to AFSA and AFSA's emergency arbitration process. And obviously the process they've created is to ensure that parties in an arbitration context can go to court, to emergency arbitrator on an urgent basis, and an award is then rendered within 14 days. Now, the other party doesn't comply with that, they obviously need to go to court. So it's important that we have a court system that also supports that process. If the party doesn't comply with the emergency award, I know I can go to court, and the court will, within 7 days, or whatever the case is, confirm you must comply. So it's an important function of that process, and it's the economics you've also mentioned.
Yes. See, the only answer we have for that need is to find a place on the urgent court. Now, what's urgent is urgent. What we've tried to do by creating specialist channels is to drain the urgent court of matters in order to make it more manageable. So urgent insolvency matters are out of the urgent court now. Urgent family matters are out of the urgent court. So there's now a smaller case flow for the two judges which we marshal to deal with that. So in a specific week, there might be tons of time to deal with a matter like that, but there's no guarantee that that will be the case the following week. What one hasn't the capacity for is to have a genuine standby judge. I experimented with that 2 terms ago, and it was a disaster. Just didn't fit in with the way the work flowed. What would be wonderful is to have a judge rostered with nothing to do, waiting to spring into action on no notice at all in order to deal with these things. Were we to have the optimal complement of judges, that would be certainly something I would contend for. But as long as the available complement of judges are stretched as it is, there we have it. One of the perennial dysfunctionalities in Gauteng, and it's not applicable to every division, no time is rostered to read opposed motions or appeals or to write judgments. That's all night work and weekend work. I mean, Management 101 says you don't design your system so that overtime is necessary. Well, we didn't read that handbook. If you think about, just by way of contrast, the way the SCA works, those of us who've gone to the SCA, oh my goodness me, we are now at the pinnacle. It's like going on holiday. Half the time you're not in court, you can read, you can think, you can even go for a run. Not in Gauteng, you know. Every single day of the week is a work day. And if you, as a person, are healthy and you've got stamina and you're committed and you haven't become jaded yet, you can manage that kind of workload for years. But some judges wilt under that pressure. And that's part of the problem that we have in effectively exhausting the judges that we have. It makes it a very unattractive future career for practitioners who come and act and see what the reality is on the dark side. So these and many other soft issues, if I can put it that way, need to be resolved in any ideal restructuring of the court system.
Thank you, Justice. I think I'm going to turn to Gregory now, just on cost. And maybe as a lawyer, you've had a formula there setting out all the different elements in terms of why it is. It seems what you're ultimately saying is it's more cost effective for a party in a dispute or full-blown dispute to rather arbitrate the dispute than go to court because of taking into account all the factors that the Justice has mentioned, where your first trial date potentially would be in 2032. If you start your arbitration today, you can most probably finalize that process either by the end of this year, depending on the parties, or sometime mid next year. Is that a correct statement to make?
So, well, I would say that is this on?
It should be.
Is that okay? There we go. So what we're looking at is just the present value of the settlement value under arbitration would be generally higher than the present value of the settlement value under litigation. So when you meet that condition, then economics dictate that you should rather arbitrate. But obviously the economic factors that need to come into play for that to work, one of which is a higher interest rate environment scenario, which we have at the moment, and also just keeping claims inflation under control. So if you can keep those two factors under control, then for the vast majority of cases, you'll find, especially a higher net worth case, you'll find that you have this increased current day value of the settlement under arbitration.
And that takes into account the fact that in a context of an arbitration, you would obviously have an arbitrator, either one sole arbitrator or a panel of two arbitrators, and that cost is factored into the cost benefit.
So the minute you have, so what we're saying is the increase in the present value would justify X number of days of arbitration. So, for example, if you have like a, say, 200,000 Rand increase in your current day value of arbitration over litigation, then you could justify, say, 4 or 5 days of arbitration and still be in the positive.
Yeah. Henk, in terms of how, when we talk about the Ciarb, in terms of what they're also doing in terms of promoting arbitration, this is part of the factor that is taken into account when you go out and promote arbitration, as opposed to litigation, because litigation is part of the system also.
Absolutely. One of the things that we also attempt to do is to ensure that if an arbitrator is appointed to the matter, that arbitrator deals with the matter on a disciplined manner and ensure that time periods are strictly adhered to, so that you bring down the time period and you bring down the period in filing of the issues, so that you can have an expedited hearing and expedited finalization. So time is a factor, and the time plays a factor into ensuring that the costs are beneficial to the parties in the process.
Definitely. And I'm now turning to, maybe, I'm not sure if it's controversial or not, but obviously we all know that Brent also mentioned this constitutional challenge on the mediation directive. And maybe just some views from the Justice and Henk in terms of that and what your thinking is, because ultimately, I think, Justice, you've explained what is the fundamental rationale around the mediation directive, what its role is in making sure that actually we reduce the role but also make the court more efficient in the long run. What is your, I'm not sure whether you want to comment on that, what is your view, or if you have a comment on that?
Well, look, I obviously need to be careful about what I say about that, because even if I don't sign an affidavit, it's almost inevitable that I'm going to be the source of the information that the deponent does have. So let me simply state some common cause facts. The controversy is whether or not there's a breach of Section 34 of the Constitution, which guarantees access to a court. So what are the facts? If you have a trial date in 2032, and we withdraw the trial date, as we have, what is on offer as an alternative is a date within 18 months of you requesting it. If you came back to us this week with a mediator's report, we would give you a date, if it was an RAF matter, in January 2026. That's the effect of a matter in 2032 sacrificing its place on the roll. If you're not an RAF matter, and the removal of matters from the roll runs from January 2027, so you had a date in January 2027, now you don't have it. You come back to me in the course of the month with a mediator's report saying we can't resolve it all. I will give you a date in January 2027. You'll be no worse off. In all of the matters which are on the roll during the course of 2025, stay there. The matters that are on the roll in the second term to the end of June are completely unaffected. But if you have a matter of any kind in late July and August of 2025, you're expected, if you still need a judge, to come with a mediator's report. That means you've got 3 months to find an appropriate mediator, endeavor to settle nothing, settle something, settle it and withdraw it from the roll. Question for debate is there a reasonable notice period? Assuming that you're a pair of competent attorneys. The argument obviously turns on a value assessment about whether that's reasonable. That's the effect of the directive on people who might consider whether or not they're aggrieved by having their dates reallocated. Is that a breach of Section 34? Well, that's the debate.
Yeah, no, that's
Yeah.
the thing. Fundamentally, I think we would say it's not, but obviously others would say it is. Henk, what is your view on that?
Well, I share your view, and I echo what the DJP says. Of course, getting a matter on the roll earlier because of the mediation process is laudable. In the event that you can't settle anything, will you have the benefit? If you're in the position where you've settled something, or you've settled some of the issues and you've allowed the parties to sign off on those will be beneficial to you down the line in terms of your time saving in the trial as well. In the event, of course, that you've settled all, well, bravo.
Yeah.
You save a lot of time, energy and space and costs, and the cost beneficial curve is in your favor.
Yeah, no, for sure. I think maybe just as a remark to some lawyers, it's not about the client's interest, it's more about their own personal interest, and that's why you would have you'll have lawyers who would rather prefer to use the court system as opposed to mediating, because in their view, the lawyer's role is more minimal in that process, which is rightly so, and it takes away fees and costs. So I think there's also a personal benefit. That's why some lawyers would say, no, I don't want to mediate.
Well, of course, in that argument, the arbitration process is helpful because you'll still
that's why
have your trial, but in a
arbitration
shorter
process
period of time.
is helpful, yeah, indeed. I'm not sure, we're running a bit out of time or over time. If there's any questions from the floor, see there's a lady with her hand up. And we can maybe take 3 questions and... I think it's off.
Can't hear.
Thank you. That's better. I'm going to start with the 2-minute soliloquy before I pose my question. I think I'm entitled. We've been sitting here for a few hours. what I want to say is, I want to pick up with the question that you posed, Jackal, at the beginning of your panel discussion. You asked, what can arbitration as a sphere, or more specifically the firms, do to assist judicially to, I don't know, to concretize the arbitration model? Perhaps that's as I understood it. And from my perspective, that really depends on what I think is legitimacy. And legitimacy is because arbitration by its nature is a voluntary process. Legitimacy, to me, is a twofold notion. First, it's the enforceability of the award to start off with, because litigants want to know that they've arbitrated and at the end of the day they can enforce the award. But secondly, and most importantly, legitimacy depends on engendering trust in the system. I litigate because I want an independent outcome in respect of my dispute. And that is why I go to court, for a third-party objective person to tell me 1, 2, 3. Objectivity is dependent entirely on social context. And to me, what that means is diversity in the appointment of arbitrators. And the arbitration sphere is one of the most untransformed spaces that I have ever come across. And I don't say this lightly. I say it for this particular reason. What it creates is the cynical view that you are outsourcing litigation to a third-party arbitrator to achieve an outcome that may be more favorable than the appointment of an independent judge. You neutralize that when you are diverse. You neutralize that when the person who you are presenting your case to either looks like you or is drawn from a panel of persons that you have comfort in, who understand the nature of your dispute, and you're entitled to that. That is why you go to arbitration. You go to arbitration because you don't want an unknown judge to adjudicate your dispute. You want to have the comfort of a particular arbitrator to determine your dispute. And that's why we wave this principle of party autonomy around as being so sacrosanct. My question is, and I ask this for 2 reasons. One, because I believe that you can only assist as a parallel process if you create legitimacy. And for me, I would wait until 2032 if I knew I was going to get an independent judge versus sitting in an arbitration process now where I questioned the legitimacy of the process itself. And I ask and I say to myself, but what is the space doing to create legitimacy? What is the space doing to create legitimacy from the perspective of transformation? How are you bringing into the fold more women arbitrators? How are you bringing into the fold more black arbitrators? And that's important from 2 perspectives. First, because as a private litigant, you are entitled to it. I mean, Jay-Z sued the American Arbitration Association because they presented a list of 18 white male arbitrators to him. And they settled on the basis that the Arbitration Foundation came back and presented a diverse list of arbitration. But I ask it also from the secondary perspective. You need diversity in order to be able to convince your clients in their dispute resolution clauses to first of all, elect to have a dispute resolution clause in their contract. And second, you need it because government is the biggest user of of litigation services in this country. And government has monitoring and enforcement mechanisms from a transformation perspective. So the state attorney, as misleading as those statistics may be, they are able to account for the extent of transformation. And if you want to get the biggest litigator to buy into this system, and you want to create legitimacy from an enforceability perspective, this space needs to change. So I put the question back to the panel. What is being done at the local level to transform the arbitration space? Thank you.
Thank you. I think obviously that's a valid question, but should we maybe first take a few others and then we can answer all of those as we go? There's another lady at the back.
Good evening. My question might be more directed to the DJP and Advocate Lowe. With the advent of arbitrations, that's been used quite extensively in the contracts and in the construction industry, and that has resulted in a dearth or an absence of jurisprudence being built up in our cases and in our reportable case law. How do we, with us encouraging litigants to go via arbitration, going to maintain that balance, ensuring that we do still get the cases that come to court and we're able to develop our jurisprudence in that respect?
And then I think the last question, any last takers for a question? Going once, going twice? No one, okay. And then just before the panel answers, so we have Edwin Glasgow also online. He wants to make 2 comments, but I think we'll allow him to make the comments after the panel response. I will also maybe just give my 2 cents on your point on transformation, but I don't know if the Justice want to go first, or Henk and Craig.
All right, well, I don't mind starting. I don't find myself in a position where I can make any comments on the issue of diversity. I'm not informed, and I'm not in a position to participate in addressing that, so let me leave that for others. On the question of the sacrificing of jurisprudence because matters of moment are sucked into arbitration, that has been an argument against arbitration in the corporate sphere for a long time. One of the potential solutions for that, which has been punted from time to time, is to have arbitration law reports. They don't work. There was efforts to do that in the labor relations field with private arbitrations. They don't work. They simply don't have the heft in the marketplace that's using arbitration. Whether or not there is a genuine loss of jurisprudence is actually difficult to put one's finger on. If we assume there's a risk of it, how might we deal with that? One of the ways would be is if parties buy into an appeal. To some extent, jurisprudence on arbitration does come up in review matters, so it's not entirely lost. And if we think about, particularly in the corporate sphere, I don't think it's necessarily true in other spheres. If you have an arbitration in a construction matter or in an insurance matter, as the case may be, and there is an appeal point or a review point that comes up, it's normally a matter of law, which then can be ventilated again in a court. You're not going to get a revisiting of factual findings, generally speaking, unless there's some monumental misdirection. I'm not sure that there's much law left that we need to develop in regard to that. So if there is a risk, and it would be interesting to see some actual studies demonstrating that opportunities were forfeited, then the way that might be resolved is if one encouraged the opportunity to appeal. But you'd have to buy into that. There are a multitude of reasons why one would choose arbitration, and in many cases would be precisely because you don't want a second helping. So those are legitimate choices. And if the parties have made that choice, then I don't think it lies in their mouths to complain about the forfeit of jurisprudence if a juicy legal point arose that might have been worthy of finding its way into the law reports. But I'm not sure that we really have enough information to drill down into that to make any concrete critiques one way or another.
Thank you, Justice. Henk, do you want to add to that?
I'm in agreement with that, but of course you do have the United Nations Intertrol, who have their own body of case law that they publish from time to time on various issues that go before them, and there's a disclosure in terms of that. I'm also aware of the fact that AFSA is in the process now where they want to create the AFSA reports, and parties can either agree to their matters being published or matters can be redacted so that those legal principles do indeed flow through in the process. And then, of course, on appeals and reviews, the matters would then indeed come before the courts, and people do indeed have access to that. So yes, indeed, it may or may not cause a situation where less is published, but there are also manners and methodologies currently to address that, as far as I'm aware.
Okay.
Then on the issue of legitimacy and diversity, of course, it is a process of party autonomy, and if people enter into arbitration agreements and they have an appointment authority, they can, of course, inform the appointment authority of the arbitrator that they wish to appoint by selection between the parties. In the event that they can't reach a selection on certain criteria, then nothing prevents the parties of going to the appointment authority and saying, appoint me someone who is X, Y, Z, this is the knowledge, this is the criteria, this is the age, and someone may be appointed from that. But with that, you also need to consider that an appointing authority does have a reputational value that it has to protect. I know that the Association of Arbitrators only appoint arbitrators from their fellowship group. The Chartered Institute also only appoints people from different criteria, and then you also have the President's List, where you have chartered arbitrators. So for parties to be on those lists, of course, they have to qualify themselves and get themselves on those lists. And if you don't want to use that appointing authority, the parties are at liberty to go somewhere else and find someone else. So party autonomy can cater for diversity and the selection of an arbitrator to be appointed.
Thank you, Henk. Maybe just to add to that, certainly this has been a debate, not just in South Africa, but globally for many years in terms of diversity inclusion in the context of arbitrators in particular. So because arbitration, as Henk has pointed out, is fundamentally a voluntary process, so the parties must consent to who will be the arbitrators, and a number of institutions, whether it's ICC globally, whether it's AFSA in South African context, I think they have a policy now dealing also with diversity and inclusion, where if you go to AFSA's list of arbitrators, there would be a variety of arbitrators who are from different races, and obviously females, males, and so on. So it is also a process of we are a big proponent for ensuring that when we appoint, whether it's from a council perspective, whether it is the arbitrator, that there must be diversity and inclusion, because you want to make sure that whether it's the arbitrator, whether it's the council, they're also representative of the society we are within, also the client. So it's an important consideration that there must be cognizance and recognition that when there's an appointment, there must be consideration of is there, whether it's a female, whether it's a particular racial group or a particular ethnic group should be appointed. And this is now, when you look at it, also globally. So there's a big push more to appoint females, if you look at it from a global perspective. But we need to change that, because if you look at, let's take one of the biggest, and we're talking about investment disputes, we talk about exit. And they appoint for most investment arbitrations. If you look at the appointment of exit, and this is all public knowledge in their reports, most of those arbitrators are European appointed arbitrators, either from the UK or the European continent, some Asian, some South American, and then from the entire African continent in totality, there's probably only 4 African arbitrators that will be appointed annually. So there's a big need to talk about, as you say, legitimacy. When I see someone, I need to also be able to identify with that person. So it's a debate, and something that we need to ensure that whether it's Ciarb, whether it's AFSA, whether it's the other appointing authorities, it is part of their policy to make sure that when an appointment is done, the parties are also content with that appointment, and you don't have a challenge to that. So it's a definitely a valid point. Yeah, and I think Gandhi, you want to say something? And then the last comment, I think, just from Edwin online after Gandhi, because we have to close.
Thank you. I know I don't want to talk more about the issue, but I think for me the issue is that currently, as it stands, there is clear demonstration that the system that uses panels is not working. As an example, we know of people who have done arbitration for many years and they are in various panels, but they just don't get appointed, number one. As a result, they don't get the experience. As a result, they are automatically filtered out from the system. I do believe that with the processes that we are thinking about now, it is very important that we should think about how do we ensure that people who are stepping forward and are seeking to capacitate this process are nurtured, number one. Number two, are given the experience that they are required, because as Henk was saying, there is no point of saying we will only appoint fellows, because to become a fellow you need to have the experience and you need to have been able to do certain things. And I think as we think or chart a way forward, it is important for us to look at the issue of how panels are used. Even now, DJP, I've observed, for example, a number of firms that are bringing themselves up as mediators for the courts, are registering, are doing all sorts of things. The same question will still arise as to how do you appoint people outside the autonomy of the parties to appoint whoever they wish to do. But I do believe that it's an issue that we cannot escape. We need to deal with and find ways of resolving it. Thank you, Chair.
Thank you, Gandhi. Is Edwin online? Can he? Okay.
I am. Can you hear me?
Yes, we can hear you. Please carry.
Thank you. I just wanted to say two things, if I may. First, I apologise for not being with you. As one of the vice presidents of ABSA, I'd intended to come, and I'm afraid domestic problems at home have prevented me from coming. But I did want to express my admiration for the quality of the debate. I thought it was absolutely stunning, and I've enjoyed every word of it. I just wanted to add two comments, if I may. One is the importance of diversity at ABSA is something we hugely recognise. I think if you take an open-minded look at the makeup of the court, you will see a more culturally diverse court than any other arbitration body has to offer. And so far as the panel are concerned, the point that's just been made is entirely valid. But at ABSA, it will be appreciated that we are working on that actively. We're one of the only arbitral institutions that does. We hold now our annual workshops in memory of Pat Lane, at which we try to encourage the exchange of quality and the increasing of quality of arbitrators who want to join the panel. I did want to just add one word, if I may, in my domestic capacity as one of the counsel who persuaded the Court of Appeal in London to change its mind about Merthyr Tydfil. The reason why our mediation can now be ordered by a court is entirely right. And the idea that the court completely misunderstood, I think, Article 6 and your own Section 24, the idea that by compelling parties to mediate before they go to court, you're doing away with one of their constitutional rights is utterly misconceived. We've put that right in Merthyr Tydfil. And the other point that was made is, I hope that as a result of Merthyr Tydfil, one of the arguments that I presented was that we should give up talking about alternative dispute resolution. Arbitration and mediation are part of the dispute resolution system. They are entirely equal to litigation and the court system. We should drop this word alternative. All three are equally important. Again, I'm so sorry that I'm not with you, and I'm sorry I'm not even properly dressed. I didn't intend to speak, but very many congratulations and to you, at least some of you, at the next workshop that we run. Thank you so much.
Thank you, Edwin. We appreciate your valued comments. And I think that should be the end of our discussion. Thank you to the panelists. Again, thank you, Justice, for the insights. Thank you, Henk, also for those wonderful insights. And Gregory on the cost benefits. I think we can give everyone a round of applause. And we're going to do the closing. So I'm going to hand over to my colleague, Zandile, a future arbitrator, to do the closing remarks.
Yes, thank you so much once again, everyone, for showing up today. It was a really good turnout, as you can see, but also the dialogue was quite pressing and important, and that was made clear today. So on behalf of the Chartered Institute of Arbitrators, the South African branch, As I mentioned, I would like to thank everyone, but most importantly, I would like to thank CDH for collaborating and partnering with us in this very important dialogue. So I would like to thank the CEO. Unfortunately, he has left for his opening. And most importantly, I'd like to thank Jackwell for your collaboration and partnership in planning this event to its delivery today. In the interest of time, the most important key speaker today, to you, Deputy Judge President. Thank you so much. And the stance that you have taken and continue to take in terms of the various propositions that you have listed, from restructuring the whole court system to filtering via mediation, but also diverting to trials, which was today very much clear that not only for us, I think lawyers' numbers are not so important, or we don't really understand them much, but today it was very clear that numbers actually do make sense. Arbitrations are more viable, cost-effective, and obviously procedurally fair and flexible. So that was driven today, but the most important part also is to thank Hank, our chair, his leadership in our committee. And last but not least, I know that everyone has raised some point in terms of transformation in appointing bodies. I think now as we all collectively make noise around dispute resolution, I'm not going to say alternative dispute resolution, but around dispute resolution and the whole arbitral realm, how do we resolve disputes? We have collaborated together with CDH to continue this dialogue, not only just as, now mediation, arbitration is key, but also how do we then make an impactful change, right? How do these appointing bodies, along with us as arbitrators or practitioners in this industry, make a change? So in that, we'll be continuing this by having webinars, and these webinars will be held every 6 weeks. We hope to keep to that timing, but we also welcome you to then obviously give us some notes, give us pointers on discussions that you would like to have, because I think this is obviously an evolving sector. We're all trying to restructure, as the Deputy Judge President has also outlined, and trying to create that framework that Hank has mentioned in terms of the parallel framework as an immediate effect of how do we then resolve disputes within the South African context, but also attracting international investment by giving confidence that we do have a system for you to resolve your disputes. Thank you once again. And I'm going to give to Jackwell now to finalize in terms of thanking you all from CDH.
Thank you. Thanks, Zanele. Thank you, Zanele. That was a very good closing. I don't think I need to say anything more, actually, because you've covered everything. We do appreciate the support again of the Ciarb for making this possible. And as Zanele has pointed out, we intend to, in the next, on a 6-week basis, we will be running webinars where we want your input. We might send you a survey to find out what do you want to talk about, whether it's on mediation or arbitration, or from the court system perspective. So please, when you get our survey, please do complete it, because it will help us to also assist in developing a bespoke program for the webinars that we intend to do. So we really appreciate that you made time to be here until this time of the evening. It shows how much you love dispute settlement and the commercial elements to that. So thank you very much from CDH's perspective, and again from Ciarb. We do have, obviously, cocktails after this, so if you want to join us afterwards, there's some food, cocktails, and you can network, and we can talk more about arbitrations, mediations, and all the other things that goes with that. Thank you again, Justice, and everyone else. Thank you. And that's a wrap.